this. Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2. My name is Judge Terrence Holmes. I'm the presiding judge here. You have been asked to come here this morning for what is called the arraignment docket. The arraignment basically is an opportunity for the court to inform you as to what you've been charged with, what your rights are, and what options you have regarding your case. The case that you have in this court is classified as a misdemeanor case. Criminal cases are divided into felonies or misdemeanors. Your felony cases are commonly referred to as your most serious criminal offenses, and your misdemeanor cases are normally referred to as your petty offenses. Now, it does not mean that the misdemeanor offense is not serious. The misdemeanor offenses is divided into 3 categories. You have a Class A misdemeanor, a Class B misdemeanor, and a Class C misdemeanor. All of those different misdemeanors have different range of punishments. For a Class C misdemeanor, it is a fine only. Your Class C misdemeanors are normally handled in the city court or the municipal court or the JP court, which is normally referred to as the justice court. They usually, cases such as a speeding ticket, not wearing a seatbelt, etc. Those are those type cases as Class C misdemeanors. Your Class A and B misdemeanors offenses, you can have an assault, family violence, which is a Class A misdemeanor. You can have a criminal mischief. You can have a theft, Class A or B. You can have a assault, family violence, which is a Class A. You may have violation of protective order, which is a Class A misdemeanor. It could be as I said earlier, a theft case, which is could be a Class A or Class B. You could have a possession of a controlled substance, penalty group 2A. It could be that's normally referred to as our synthetic marijuana. It could either be a Class A or Class B, or you could have a possession of a marijuana, Class A or Class B. You can have driving while intoxicated. It could be a Class B, or if it's a driving while intoxicated with an alcohol concentration of 0.15 or more, it could be a Class A, or if it's driving while intoxicated. Second is a Class A misdemeanor. You may have a failure to ID offense. Normally, it could be a Class A or Class B. Criminal trespass, if it's in a residence, it's normally a Class A offense. If it's outside of residence, it's a Class B misdemeanor. You may have an evading arrest, evading detention, resisting arrest. They are normally classified as Class A offenses. Now, for a Class A misdemeanor, which is the highest misdemeanor that you have, the range of punishment, you could be given confinement in the county jail anywhere from 0 days to a year, which is 365 days, or anywhere in between. You could be given a fine from $0 to $4,000, or anywhere in between, or you could be given both such fine and confinement. For a Class B misdemeanor offense, the range of punishment can be confinement in the county jail anywhere from 0 days to 180 days, which is 6 months, or anywhere in between. A fine from $0 to $2,000, or anywhere in between, or you could be given such fine and confinement. Now, you may qualify for probation. Now, if you get probation, you don't necessarily go to jail. You are normally out in the community. That's why they call it community supervision. Now, there are 2 types of probation that you may qualify for. One type of probation is called adjudicated probation. We normally refer to as your regular type probation. The other type of probation is called unadjudicated probation, and we normally refer to it as deferred probation. Now, the difference between the 2, with the adjudicated or the regular probation, it does result in a conviction on your criminal record. However, there's something that's called judicial clemency, whereby the court can set aside the conviction and you will no longer have that conviction on your record. Now, what has to happen is, first of all, you have to successfully complete your probationary period. The time has to expire. You cannot have any more time left on the probation. And then the court has to discharge you, which means to let you off of the probation. And then the court can allow you to come back in the court to withdraw or take back your plea of either guilty or no contest. And if those things happen, then the court can set aside, then any complaint, affidavit, or information that has been filed in your case can be dismissed. And then the court can set aside the conviction, which means you will no longer have a conviction on your record. However, if you get a subsequent offense, or if you get an offense later on, a conviction later on, and it's brought to the court's attention, then if you applied for a license with CPS, it could be used against you, and then they could deny giving you a license, or if you do not have a license, they could they can deny giving you a license, or they can revoke your license, or they can suspend a license that they have previously given to you. All right. So now with the unadjudicated or the deferred probation, it does not result in a conviction on your criminal record. And if you successfully complete the probation, then what will happen is the case will be dismissed, will not result in a conviction in your record, and you may qualify for what is called a non-disclosure. A non-disclosure basically means that we cannot disclose to the general public the fact that you were on deferred probation for this case. However, if you violate your terms and conditions of your deferred probation, the state can file a motion to revoke your unadjudicated probation. If that happens, you'll be arrested, you'll be entitled to have a hearing, and if you have a hearing, if the court finds that you have violated your probation, the court can revoke your unadjudicated probation. And if that happens, you can get a conviction. If you get a conviction, obviously the case is not going to be dismissed and you cannot get a non-disclosure. Okay? Now, the paperwork that you have in your hand that has been passed out to you, the first document states, the title actually states that, it states judge's explanation of rights to defendants without an attorney. And it's read as follows. As a defendant in a criminal case, you have three options. Number one, you may hire an attorney. Number two, if you do not have enough money to hire an attorney, you may request an attorney be appointed to represent you. Number three, you may represent yourself. So those are your three options. If you want an attorney to represent you and have enough money to hire an attorney, the case will be reset to give you time to do so. If you want an attorney and do not have the money to hire one, you will need to fill out a financial questionnaire so that the proper person can determine whether or not to appoint an attorney to represent you. You may not speak to the prosecutor. The prosecutor is the assistant district attorney, the person who is handling the case for the state of Texas. Okay. You may not talk to the prosecutor about your case unless you sign a written waiver of your right to be represented by an attorney. The written waiver actually is the second page on the clipboard that you have. Okay. You say, be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant legal rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. If you choose to proceed without an attorney, You may change your mind at any time and may request counsel from the court. Now, at the bottom of this document on page 1, it states, Defendant's Choice, mark initials next to only one choice. Now, if your choice is, I want to reset this case to hire my own attorney, then you'll put your initials on the first line to the left. If your choice, if you have already hired an attorney to represent you, then you'll put your initials on the second line to the left and the name of the attorney on the line to the right. If your choice is, I want to apply for court-appointed counsel, then you'll put your initials on the third line to the left. If you've already have been appointed an attorney, then you'll put the name of the attorney on the line, on the fourth line to the right, and your initials on the fourth line to the left. If you want to waive your right and represent yourself, then you'll put your initials on the fifth line to the left. Now, once you have finished initialing one of those lines, then you will sign at the bottom of the document where it says defendant. You're going to place your name there and today's date, July 27th of 2021. Now, for those individuals who will be representing themselves, you will have to sign the second page. And the second page is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. And it reads, I have been advised of the nature of the charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily and intelligently made. Furthermore, I have been advised this 27th day of July of 2021 by County Court at Law number 2 of my right to representation by counsel in this case pending against me. I have been further advised that if I am unable to afford counsel, one will be appointed for me free of charge. Understanding my right to have counsel appointed for me free of charge if I am not financially able to employ counsel, I wish to waive that right and request the court to proceed with my case without an attorney being appointed for me. I hereby waive my right to counsel. And if that's your choice, you'll sign on the line where it says defendant, and you'll place today's date, July 27th, 2021. Now, ladies and gentlemen, you also have other rights. You have a right to have a trial by jury. And what a trial by jury is, there'll be 6 people who will be selected to sit on your case. They'll sit in that area over there. We call it the jury box. They'll listen to all of the evidence, and once all of the evidence is in, they will decide whether or not you're guilty or innocent after listening to all of the evidence. You have a right to waive your right to have a jury trial, which means you have a right to give up your right to have a jury trial. And if you decide to do that, then your case will come before the judge. Now, you can come before the judge either through what is called a bench trial, or if you enter a plea of guilty or no contest, and if you want to enter a plea, you can have what is called an agreed plea or an unagreed plea. An agreed plea means that you and the state have worked out a settlement on your case, and when you call that a plea bargain agreement, that's why they call it an agreed plea. Now, if you and the state have not worked out a settlement on your case, you still can come before the judge on what is called an unagreed plea. And by doing so, you'll be asking the court to set punishment in your case. You also have a right to have witnesses, to call witnesses in your case. Now, where that young lady is sitting, we call that the witness stand. And what witnesses do, they can testify. They can testify for you or against you. You can ask them questions. We either call it direct examination or cross-examination. You also have a right to waive your right or to give up your right to have witnesses to come to court to testify in your case. And by doing so, you will not be calling witnesses. However, the state will be calling witnesses. You also have a right against self-incrimination. Self-incrimination basically means you have a right not to testify in your case. We call that the right against self-incrimination. Now, you can waive or give up that right of self-incrimination, and you can decide to testify in your case by waiving your right, or you waiving your Fifth Amendment right against self-incrimination. You also have a right to see the evidence that the state has against you before you go to trial. We call that discovery. In essence, you have a right to discover or see the evidence that the state has against you. You can look at documents, you can look at witness statements, videos, DVDs, whatever evidence that they have. You'll have a right to have access to that evidence. Now, if you're represented by an attorney, your attorney will have a right to have access to that evidence. Now, if you're representing yourself, you will have a right to have access to that evidence, but the state is not allowed to give you any copies of that evidence. Now, if you and the state are able to reach a plea bargain agreement, in essence, y'all been able to work out a settlement in your case, and your case comes before the court or before the judge does not have to follow that plea bargain agreement. If the judge does not follow your plea bargain agreement, then you will have the right to withdraw, which means you have a right to withdraw your plea or take back your plea. For example, you come before the judge and say, well, judge, we have an agreement in this case, and the agreement is, say, to serve 5 days in jail, credit for time served or whatever. And the judge say, well, I'm not going to follow that plea. We'll say, well, judge, I take my plea back. You have a right to do that. Now, if the judge does follow the plea bargain agreement, and if you decide within 30 days that you would like to appeal your case, what an appeal is, you would like to have a higher court than this court to look at your case to see whether or not you've been wrongfully convicted, whether or not the court committed an error by convicting you. And you would have to get permission from the court to appeal your case. If the court follows the plea bargain agreement, you would have to get permission from the court. Now, if the court gives you permission to appeal, your case will be appealed to the Ninth Court of Appeals, which is located on the 3rd floor of this courthouse. It actually is right above us. And they can either grant or deny your appeal. If they grant your appeal, then they can simply find you not guilty, or they can send the case back down to this court and order this court to give you a whole new trial. If they deny your appeal, then you can appeal it to a higher court than the Ninth Court of Appeal. That court is called the Texas Court of Criminal Appeals, located in Austin, Texas. It is the highest criminal court in the state of Texas. Now, you will have to file what is called a pro se petition for discretionary review. Pro se means you'll be handling this on your own without the assistance of a lawyer. And you'll be asking the Texas Court of Appeals to determine whether or not your appeal should have been granted, whether or not you've been wrongfully convicted, or whether or not the court committed an error by convicting you. Now, that would have to be done within 30 days of the denial of your appeal from upstairs. Now, if they grant your pro se petition, they can simply find you not guilty, or they can send the case back down to this court and order this court to give you a whole new trial. Now, if they deny your pro se petition, at that point, your conviction will stand. Jefferson County, the DA's office that is, has a program that is called pretrial diversion. Pretrial diversion is a program for first-time offenders. If you ain't never been in trouble before, you committed an offense for the first time, they have a program where they will put you in the program and dismiss your case, and you could get that case expunged from or wiped off, deleted, or erased from your record. And the way it works, first of all, you have to have a lawyer to assist you to get into the program. It has to be your first case. You cannot have a criminal history. And it cannot be a case involving resisting arrest or unlawfully carrying a weapon. Okay? And if those things, now, if you get into the program, you successfully complete, the case is dismissed, you complete the program, you can get it expunged, deleted, erased, or wiped off from your record. Now, if you are a veteran of any one of the branches of the United States military, they have a program as well, which is part of the program, which is part of the pretrial diversion program. That program is called Veterans Court. You just have to be a veteran to get in the program. You get in the program, complete the program, case dismissed, you can get it the case expunged from your record. All right? This court has a program that is called the Community Safety Initiative. I usually refer to it as a CSI program. It is a program designed to make Jefferson County a safer place for all of us to live, work, go to school, raise our children, raise our family, go to church. And the way the program works is we have partnerships with agencies in the community. We have a partnership with Spindletop, MHMR, or just Spindletop Center now. They have, they're the local mental health agency in our region. And they have a drug and alcohol counseling program that is called ATAR. ATAR stands for Addiction Treatment and Recovery Program. We also have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University. And Lamar University has a program called CICE, stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training and a job placement program in the hotel industry, the shipping industry, and the chemical industry. You'll be given training in one of those areas that you select. And once you finish your training, they will assist you at getting a job in the area that you trained in. Now, with Spindletop Center, what they will do is they will do, we have individuals in court who will do a private interview and with you in our conference room, and they can develop a treatment plan. They can do an assessment, develop a treatment plan, either outpatient or inpatient, to meet your mental health needs. If you have an issue with drugs or alcohol, then with ATAR or with OZAR, which is the local drug and alcohol council, they can do an interview, they can do a screening, and they can develop a treatment plan, either inpatient or outpatient treatment, to address your addiction needs. And if you have not completed high school and you would like to get your GED, this CICE program at Lamar University has a program where you can get your GED. Now, all of the programs that I've just mentioned does not cost you anything. They are free. Only thing you have to do is have a desire to be in the program. The other benefit to the program is all of those programs that I've just mentioned can be used as community service. Now, everyone in here have been arrested on their case. You have bonded out on the case. And so if you stayed in jail 1 minute, that's considered a day, because you booked in that day and got out that day. And so some people stayed in more than one day. So whatever time that you stayed in jail, you can get credit on that toward your punishment. So for example, if you spent 5 days in jail, the state offers you 5 days in jail, you won't have to do any more time because you'll be given credit for time served. Or if they offer you 7 days, you did 5, then that only means you have to do 2 because you're going to get credit for the 5 that you've already served. If the state is offering a fine and court costs, let's say you spent 5 days in jail, let's say this fine and court cost comes to a total of $500. You get credit at every day that you stayed in jail, you get credit at $100 per day. So if you was in jail 5 days, that's $500. State is offering you fine and court costs of $500. You will not have to pay the $500 because the 5 days that you spent in jail has already paid it off. Therefore, the fine and court costs, you'll be given what we call, the fine and court costs will be taxed and retired. You won't have to pay it because the time you spent in jail has already paid it off. Now, if they offer you a fine and court cost of $700 and you stay 5 days in jail, then they're going to subtract the $500 from the $700, and that means you only have to pay $200. Okay? Now, the programs that I just mentioned, all of those programs can be used as community service. If you've been given a fine and court cost and you cannot you cannot pay the fine and court costs on that date, then we could put you on what is called a payment plan or a pay schedule. You can pay it off over time. But let's say even if you been given a payment plan, you can't pay it off at all because you don't have the income, then we can convert your fine and court costs to community service. And you get credit at every hour of community service that you do as $12.50 that goes towards your fine and court costs. So if you work an 8-hour job doing community service, that's $100 that will go toward your fine and court costs. Okay. So the programs that I just mentioned in our CSI program, for example, all of them can be used as community service. So for example, if you're on a job training program, while you're in the job training program, that's considered 1 hour community service, and $12.50 will go toward your fine and court costs. So in essence, you'll be killing 3 birds with 1 stone. And how that works is you're in the program, $12.50 going toward your fine and court costs, and 1 hour is going toward your community service. And so that's the same thing is true for your mental health. If you get mental health counseling, if you're getting drug or alcohol counseling, or if you're in a GED program, or if you're in a job training, all of those programs can be used as community service toward your fine and court costs. And I tell people this all the time, when you come to county court at law number 2, we don't have court as usual, we have unusual court. And it's not because we're different, but we're trying to make a difference in the lives of the individuals that come before this court, and we're trying to make a difference in Jefferson County by making Jefferson County a safer place to live and work, go to school, raise our families, raise our children. And we are making a difference by producing productive people. And if we produce productive people do not commit, for the most part, do not commit crimes because they have too much to lose. And so now what we're going to do, you gonna say anything? Okay. What we're going to do at this time, just hold on a minute. Okay, ladies and gentlemen, what we're going to do, the paperwork that you signed and filled out, we're going to have someone come by, pick it up from you, and then we're going to put you into various different groups. You know, the groups, people who want to hire, the people who want to see if they qualify for court appointed attorney, and the people want to represent themselves. So just, it's going to take a few minutes to do that. Just hang on a minute and just be patient with us, okay?